At this time, I'd like to call the meeting to order. Today is Thursday, April 24th, 2025, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We'd like to begin by acknowledging that land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Kizh peoples. Commissioner Copeland, would you please lead us in the Pledge of Allegiance? Thank you. Madam Secretary, may you please have a roll call?
Commissioner Copeland?
Here.
Commissioner Goldman?
Here.
Commissioner Kirby?
Here.
Commissioner Topshin?
Here.
Vice Chair Rory?
Here.
Chair Bass?
Here, we have a quorum. We will now move to the approval of the agenda. Has everyone had a chance to review tonight's agenda? And is there a motion to approve?
Motion to approve. Second.
We have a motion and a second. May you please have a roll call?
Commissioner Copeland?
Aye.
Commissioner Goldman?
Aye.
Commissioner Kirby?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Rory?
Aye.
Chair Bass?
Aye. The motion carries. We'll now move to the minutes. We have before us the minutes of April 10th, 2025. Has everyone had a chance to review them?
Yes.
Please.
I do have a slight correction, if I could, Chair. Where the minutes read, sorry. A motion was made by Commissioner Copeland to form a subcommittee to review the valuation guideline amounts found in the rent stabilization regulations. That should actually read the valuation guideline amounts, items, and instructions. That's all I have, Chair. Thank you.
Thank you. Any other corrections? Do we have a motion to approve the minutes?
Motion.
And a second?
A second.
We have a motion and a second. May we please have a roll call?
Commissioner Copeland?
Aye.
Commissioner Goldman?
Aye.
Commissioner Kirby?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Rory?
Abstain.
Chair Bass?
Aye. And the motion carries. Thank you very much. We now move to the period for public comment. This is an opportunity to address anything before the commission that is not on our agenda tonight, but within our purview. Do we have any public comment at this time?
We have Eugene Maysky for public comment.
Great. You please state your name, city of residence, and you'll have 3 minutes to speak.
Good evening, Chair Bass, Vice Chair Rory, Commissioners, City staff. My name is Eugene Maysky. I'm a tenant outreach organizer for Coalition for Economic Survival, CES. First, I'd like to briefly cover the history of 1301 Havenhurst, which is the building where rent control in West Hollywood initially started. CES led an effort to win rent control laws for the first time in late 70s, but when the original try didn't go through, that led to incorporations of the city of West Hollywood. And those activists met at 1301 Havenhurst, which makes this building very significant for the history of this city. A lot of things connect to that building, and one of the tenants that is still living in that city was on their original committee. Authorizer was on the original committee that helped incorporate our city. On a personal note, when I first started working for CES, this is what my first case. This also was the first tenant association that I created in the city of West Hollywood to help tenants protect their rights and make sure that they were provided all the services that Coalition for Economic Survival is supposed to provide to the residents of West Hollywood. After that, for the past 5 years, we fought a lot of battles because unfortunately LLFO properties put the residents at high risk with multiple infractions of the code. They also broke rules with tenant harassment ordinance that our council put in place to protect tenants, rent-stabilized long-term tenants, specifically just like tenants of 1301 Havenhurst Drive. And to make sure that stuff like that doesn't happen anymore, I think it's important that we protect our residents, not because of the historic value of the building and the tenants who's been there for decades, but just because all of the residents, rent stabilized or just tenants who live in our city, deserve much better than how they've been treated in this specific building. Thank you for your attention, and I hope you can help them tonight. Thank you.
Thank you very much. Do we have any additional public comment?
No.
Thank you very much. We'll now turn to item number 7, our manager's report. Mr. Kessinger, may we have the report, please?
Yes, thank you. And good evening, commissioners. It's nice to see you all. Before I move to the look ahead calendar, I wanted to make an announcement about the 20th annual Older Adult Community Health Fair that will be taking place at the Plummer Park Community Center on Thursday, May 8th from 10 a.m. to 1 p.m. There will be booths there with different community partners, health screenings, wellness demos and local resources, emergency preparedness info, as well as a Know Your Rights housing workshop and facilitated discussion with the Rent Stabilization Division. It will be facilitated by Vice Mayor Heilman. The Know Your Rights presentation specifically will be from 10:30 a.m. to 11:30 a.m. in rooms 1 and 2. We're working on the presentation right now and are creating it to focus on issues that carry more relevance to older adults in the community, in particular areas of the rent stabilization ordinance that provide for increased protections for older adults. So we hope to see many members of the community there. There is free parking at Plummer Park. There will also be a free ADA accessible City Line shuttle every 30 minutes from 9:30 a.m. to 2 p.m. with stops at the West Hollywood Library, Crescent Heights in Santa Monica, and Plummer Park. For a route map and more information, you should feel free to visit weho.org/cityline. Moving on to the look ahead calendar, this evening we have 2 appeals. We will have 3 appeals on May 8th, May 22nd, and June 12th. As of now, we do not have appeals scheduled for June 26th, but that will likely be forthcoming. We'll also be reviewing the annual general adjustment, relocation fees, and temporary relocation expense schedule, which will all be adjusted pursuant to the change in consumer price index. That concludes the manager report at this time, but I'm available for any questions that commissioners might have.
Thank you. Do we have questions of the manager at this time? Seeing none, thank you very much. We'll now move to the appeals portion of our meeting. Tonight we have 2 appeals, and I believe we have representatives of both the tenants and landlords for both of those appeals. The way this works is first we will get a staff report from our legal counsel, and then after that the appellant will have an opportunity to speak. They have 5 minutes, and they can divide that time however they choose to use the remainder of their time for a rebuttal. At that point, the respondent will be able to speak, and then the rebuttal. So that's the way both of those appeals will go, and we will start the first appeal on our agenda this evening, 4976, with a staff report. Mr. Martz.
Good evening, Commission, and good evening to the public. My name is Kellen Martz, legal counsel to the Rent Stabilization Commission. Tonight, as the chair said, this is D-4976. The address is 1301 Havenhurst Drive. And this appeal arises from a hearing examiner's decision related to a rent decrease given for 3 housing and maintenance issues: the unit paint, the unit carpeting, and the unit linoleum. Staff recommends affirming and modifying the hearing examiner's decision, as I will explain in a moment. This matter involves an appeal again at 1301 Havenhurst Drive. The property unit number is 114. The tenant, Michael Rusnow, filed a rent decrease application for 3 housing service issues. The rent reduction hearing took place in December of 2024. Both parties appeared. And as noted, and then I think the tenant will probably bring up, there was inconsistency in the record that is primarily due to statements that were made at the hearing and that were potentially discombobulated by the hearing examiner. But I don't think that they are entirely relevant to the matter tonight. The landlord did not contest the tenant's claims or provide records about the unit paint, the carpet, and the linoleum. They noted that the documentation was not provided and they were recent owners of this property. The hearing examiner granted a rent decrease in the amount of $121, $41 for the unit paint, $62 for the carpet, and $18 for the linoleum. The appeal was filed by the tenant. The tenant has argued that those amounts are too low for the 3 housing services. The question before the commission tonight is there substantial evidence to reasonably support the hearing examiner's decision regarding the paint, the carpeting, and the linoleum? Staff believes there is substantial evidence as to the paint and the carpeting, but not as to the linoleum. In your packet, we speak to RSO Regulation 60041, which is the factors or grounds for a rent reduction. Staff believes that the hearing examiner properly analyzed and explained his or her reasoning for the paint and carpet amounts, but not the linoleum. As the commission is aware, you don't substitute your judgment for the hearing examiner. If a reasonable hearing examiner could have made the same decision, even if you disagree, then you have to uphold that decision. And here, staff analyzed some of the factors in 60041 to look at why or why not it should go up. And the issues that staff looked at that kept it from going to the highest amount is that based on the photos and some of the testimony we read, this was not a high quality of life issue. You can still walk in the apartment and whatnot. It does not impact the habitability to a high degree. Again, still can walk around and use the property. And the factor is there is a relatively low maximum allowable rent for the unit, so that should be taken into account. So staff, in analyzing the factors, believes that a more appropriate amount is a $40 rent reduction for the linoleum. All other aspects, including the findings that, yes, these are housing services and there was a substantial reduction, staff believes is correct. So the only change would be to the amount of the linoleum going from $18 to $40. So that concludes my report. I'm available for questions. Thank you.
Thank you. I have a question just to kick us off. On page 3 of the hearing examiner's decision, first paragraph, the amounts listed in the valuation guidelines appear to be the amounts that were from pre-September 1st, and this application was filed October 22nd after the evaluation guidelines went up. So the lowest amount listed is actually on the issues lower than the lowest number on our valuation guidelines that should have been in effect at the time. I'm wondering if staff has any opinion about giving a valuation that's lower than what our recommendations were at that time. I think it was just an error on the part of the hearing examiner.
Staff will happily give you an opinion when I look at that issue, but if that is the case, then yes, we should adjust those to be appropriate to the guidelines that were in effect at the time, but I'll take a look at that before I confirm my opinion.
Okay. Any additional questions of staff at this time?
Just could you give us the basis for which the 35, I'm sorry, is it 35, I think is what the increase is you're recommending?
18 to 40.
Oh, 18 to 40, I don't know where I got 35. Can you tell us what the kind of the basis for how that number was determined? I know you generally spoke about the checkoffs, but in terms of numbers, how?
I mean, this is not an exact science. So we saw the 18 and we thought that was too low. It sounded like there were chips and chunks out of the linoleum. Generally, the lowest level should be for the most minor of inconveniences. For things that have a requirement of a number of years to replace, it generally we would think, okay, you've hit the time you should have replaced, you haven't done it, but there's nothing technically wrong with them. That might get you the low end. Here, there was testimony that there were pieces missing, and I think some of the photos, so that brought it up. But then the highest level should also, on the flip side, be reserved for, it might have been 20 years and there's huge chunks missing, you can't walk in rooms, those type of things. So somewhere in the middle was appropriate from staff's perspective.
Thank you.
You're welcome.
Any additional questions of staff at this time?
Just to clarify, thank you, Mr. Martz. Yeah, I didn't see any analysis, any justification in the examiner's analysis, and also clearly decision for that $18 rent reduction, and you explain how staff looks into that and just justification for the higher amount. So I'm just wondering, would staff look into the amount of the rent paid as well as one of the factors for the rent reduction?
It is one of the factors, and again, there's nothing in the regulations or kind of in general law that if there's a set of factors, unless it says otherwise, you can kind of consider one more than the other. It's an art, not a science here, but it is one of the factors that should be looked at, and so it is taken into account.
Okay, so typically you would look into different factors to come up with that. Thank you. No further questions.
Thank you. Commissioner Copeland?
Sorry, I don't have a question for Mr. Martz, but I do have a disclosure. Is this the proper time to perhaps do that? I just wanted to disclose that a copy of the same rebuttal correspondence that we received in our agenda packet was forwarded to me by email prior to our receiving it from staff and prior to my being on the commission. I don't know either party, haven't discussed the case with them. This was a question regarding policy in general. So I just wanted to go ahead and disclose that now. Thank you.
Thank you very much. Oh, Vice Chair Rory.
I just wanted to clarify for myself and maybe folks watching at home the regulations for how often interior painting and carpet and linoleum replacement should occur. I believe is it 7 for painting or remind myself in the audience what those thresholds are.
Yep, I'll pull those up and read them. So paint rental units in interior common areas, so that could be hallways and whatnot, every 4 years. Paint exterior common areas every 7 years, and replace carpets and window coverings provided by the landlord in the rental unit and common areas every 7 years. Replace vinyl, linoleum, laminate, bamboo, or cork flooring every 7 years.
Thank you.
You're welcome.
Thank you. I don't see any additional questions, so now we will move on to the appellant, which in this case is the tenant. And so Mr. Rusnow, you'll have 5 minutes to speak. Please step to the lectern.
And started yet because I have to get my pen.
We will not start until I'm done and turn the time over to you. But we're going to have you introduce yourself by name, city of residence, and then just tell us how you would like to divide your time, if you want to divide it at all, so our secretary can keep track and let you know when that time is expired.
Okay.
And just pull the mic closer to your mouth so everybody can hear you. And
still hasn't started, right? Okay.
no, we won't start until you.
I will do my piece, and there will be a little bit of time over for rebuttal. Okay.
Okay. We will just note for the record how much time is left when you're done speaking.
Okay. Ready?
Please proceed.
Okay. Michael Rusnow, 1301 Havenhurst, High Commissioners. I've lived at 1301 Havenhurst 35 years, insured by enacted fair rent and living standards. The ordinance mandates carpeting and linoleum replaced at 7 years with painting at 4. This renovation interval would have been my 5th. I submit rent reductions for failed landlord services in the ordinance for painting, carpeting, and linoleum aren't effectively designed and are constructed with guidelines offering wide ranges without regard to unit size. But the law gives the Commission ample ways to see I'm adequately compensated. The amounts assigned to me were wrong. Staff agreed regarding linoleum. But how hearing examiner Ohl and staff concluded painting and carpeting should be small amounts displays gross unawareness of how these services affect me. Mr. Ohl said, "The failure to provide this basic maintenance is a discontinuance or substantial reduction in a housing service, the loss of which necessitates a reduction in rent." He then utilized the ranges for each service. Painting, $41 to $123, carpeting, $62 to $166, linoleum, $18 to $51. Without explaining why, he decided my 2-bedroom, 2-bath apartment should receive minimums, $41 for painting, $62 for carpeting, and $18 for linoleum. As to staff's report, its conclusions are mostly wrong and ignored my testimony and appeal letter, except for linoleum. Staff said $18 wasn't enough, recommending $40, 80% of the guideline range. However, staff said, while citing carpet photo stains, Mr. Ohl's painting and carpeting amounts were fine. Really? Staff dismisses me because holes do not exist as to the paint or the carpeting. 2-dimensional photographs don't show carpet wear, even with large stains, nor fading white paint. So no wall photographs were submitted. Why does the ordinance mandate renovation periods? It knows years take their toll. Paint fades and doesn't say holes are a determining factor. My greatest disagreement with staff, and forgive my voice rising, but how dare staff believe that the reduction in services does not affect the tenant to a high degree, is a minor quality of life issue, does not impact the habitability to a high degree, and there is a relatively low maximum allowable rent for the unit. How dare staff presume this without viewing faded stained walls not evident in photographs or reduced pile of the carpet? How dare staff presume how I feel inhabiting an apartment with diminished quality, embarrassed when guests come over to see the impact of 7 years without refurbishment, now 7 months more since my application, and I have recent photographs with me. It is to staff a minor quality of life issue, though it has been a joy after renovations to see walls sparkle and carpet with quality pile. Then the obvious rationale about being unworthy of a higher amount because I'm paying a lower rent. Rent control was the be-all of cityhood, designed to protect tenants from landlord gouging, plus fixed periodic renovations in the law. But while it mandates rent rises, it gives landlords a means to defy the law. While rent reductions aren't meant to punish landlords, they're not supposed to reward them either. Giving landlords the choice to obey the law or lose small income as opposed to thousands to renovate is an easy choice, subjecting tenants to a decline in habitability. Should long-term tenants be penalized? Should we be awarded a pittance, helpless as to whether landlords follow the law? And who qualifies for higher amounts? 166 for carpeting and 123 for painting, or 140 and 115 respectively, or even 110 and 100. Why am I really at the bottom? I appeal to you to raise my amounts to at least 80% of the maximum that staff recommended for linoleum, $100 for paint and $133 for carpeting to go along with $40 for linoleum. And I thank you and reserve the remaining time. I hope this wasn't too much for you.
Thank you very much. How much time does he have left?
42 seconds.
It's perfect. I've been rehearsing all day. Thank you.
Thank you. We will, at this point, ask if there is any public comment on this.
There's no public comment, and
Okay.
the landlord representative is not.
Okay, so we will, I will actually ask now for the record if the landlord is here and would like to make a presentation. And seeing none, it would now be time for rebuttal. If you choose to use your last 42 seconds, this would be the time to do that.
Well, are you going to ask me any questions?
We very well might, but
Okay,
we'll
good.
wait for you
Well,
to be done with your
okay.
comments first.
Well, the only thing that I could say, in case I didn't have enough time, the first renovation was helped by a then policy where somebody came from you to inspect my unit because my landlady at the time didn't want to do it. And he then said, you really should. And so she did. And since that time, in the 90s, you've stopped doing that. So everything here is totally based upon two-dimensional photos. And also, a refrigerator, I've mentioned in my letter, gives a greater reduction than carpet and linoleum combined. And yet the refrigerator, if you bought it with your money that you're saving, can be taken if you move. You can't take the carpet or linoleum should I decide to use that money, which at the moment is a pittance, to replace the linoleum, which I'm tripping over from time to time. So I guess I'm close to the 42 seconds, aren't I? And I'll sign
your
a copy
time.
of this for you if you'd like for your, interest later.
Thank you very much. I will ask my colleagues now if we have any questions for the tenant. I see none, so we...
Oh, really?
Yeah.
Oh my God, should I just leave? Okay.
The record is well prepared, I suppose. So at that point, I will close the public comment portion of this appeal and ask my colleagues, if before we move to deliberation, if there are any questions of staff. And I do want to get an answer to mine before we deliberate too far, the one from before. And Commissioner Topchin, you have one?
Thank you, Chair. It's mostly just to reconfirm that I understand what Mr. Martz you said in regards to the staff's recommendation that we should look into the what it says, modifying the $18 for the linoleum, and your recommendation is do not basically uphold the decision in regards to the carpet and the paint. But just to reconfirm that if the commission would like to explore any further discussion whether these amounts as determined by the examiner would be okay, so then the commission has a role that the commission can make that decision.
To adjust those amounts if you'd like
To adjust
yes.
those amounts.
You would need to speak to the specific factors that would bring you to a higher amount, but yes, you're welcome to
All
do
right,
so.
okay, yeah, I just wanted to start with that first. Thank you.
Thank you. And was staff able to find an answer to my question about the evaluation guidelines being used?
We are almost there, so give me one more second.
Okay, then I will ask if there are other questions of staff.
My question relates to once they find that information, I would like to have the new, if they are the applicable rates, read into the record so I could get those ranges.
I happen to write them down. If I'm correct about the dates, I can share those, but I'll wait for staff before adding more confusion.
Yeah, I would go on. It'll take me a few minutes on that, but
Okay. So what I saw that on 9/1, I went back to our August 8th meeting, and assuming we didn't change anything from the agenda, which I don't recall us doing, so just off my own memory, I didn't watch the meeting. The range for paint would be 42 to 127. That's up $1. Unit carpeting, 64 to 171. That would be a $2 difference on the minimum. Linoleum is 19 to 53. Previously, it was 18. Was be the low. So they're not huge differences, but if we are using the new valuation guidelines as of September 1st, the minimum is higher on all three of these items than it was that the hearing examiner.
So the ranges you just read, these are from the ranges as of 2024?
September 1st, 2024, and this this application was filed in October after the evaluation guidelines went into effect.
Mm-hmm.
So that's what I believe looking at the record, but I want staff to take a look at that as well.
Okay, thank you.
Because heaven knows I've made mistakes before, and I wanted a second set of eyes on this. Would you like to start deliberation, or should we wait for an answer on this? What do you all feel?
I think we should wait. I was hoping we could wait, and then I had one further question, just because I think it'll help guide when we're looking at if there is any discussion about the amounts that were awarded, the factors themselves. As I read it, it says number 8, such other factors deemed relevant by the hearing examiner or commission. So this body has the ability to articulate and justify why another factor might bear on discussions for those other issues. Is that correct?
yes.
Okay.
I would not for you or for anything, but the keyword is relevant, though. We've got to, just keep that in mind. Not going on goose chases to either lower or raise amounts. And you are correct. So the guidelines went into effect middle of September 2024, and the application was filed in the middle of October 2024. And so the correct amounts are the slightly higher amounts that you just stated.
So the hearing examiner just used an old list.
I believe so.
I mean, because those numbers are accurate for the list for the previous year.
That is right.
Okay. An easy mistake to make because it was only a month later. But with that, Commissioner Goldman, did you have a question? Yeah.
So I'd like to have it clarified, I guess, a little bit more how they decide on the effect that it has. Is it, because some of it I think can be subjective, right? So how is that kind of dealt with? Is it just the very physical nature? Is something physically impeding your living situation, or is it? Are there any other factors there? I guess because some of these things to one person it could feel like a huge imposition, and to somebody else maybe not so much. So I would imagine it would vary depending on the hearing examiner. So I'm just curious how that is dealt with.
Yes, this is a gray area, so it is subjective. The factors that are set forth in 60041 Some of them are to the tenant, and some of them are to kind of just the issue as a whole. But they all are required to be reasonable, to reasonably compensate the tenant in question. So extent to which the reduction in service affects the tenants of a given rental unit, the relative significance, so again, it's relative to other either tenants in the building or in the community at large. The impact of habitability, that's not unit specific, that's just in general. The prevailing market rate of the housing service, so what it's worth around town. The extent to which the tenants were led to rely upon the fact that the service would be provided. I don't think that's as applicable here, but if it was like a pool or gardening services, that might come into effect. The maximum allowable rent for the unit, so that is unit specific. The guidelines that you're familiar with, and then such other factors as deemed to be relevant by the hearing examiner or commission. So it is based off of the hearing examiner. Each one can be a little bit different. Each of you have your own subjective opinions on what, and so I think there is a balance in here. All of these have to be reasonable. Some of them are unit specific, and some of them are broader, not unit specific issues. So I think keeping in mind that the guideline values that we have in our regulations provide a window of an upper and a lower. You can, if you find other factors that would make you go above or below those, you're fully permitted to do that. But when you take it as a whole, the most extreme cases generally would push you up at the upper limit. The most minor of issues would bring you down, and then it's that whole middle area where it does become pretty subjective.
Thank you for clarifying.
Can I just ask you, is this a one-bedroom unit?
I would look to the tenant.
Two-bedroom?
Number of bedrooms.
2 bedrooms, 2 bath apartment. I thought I'd mentioned that.
We're just clarifying.
Thank you.
Thank you. Any additional questions of staff at this time? Then Commissioner Kirpes, you had asked to start deliberation a minute ago. Do you want to kick us off?
Yeah, I'll tell you what my thinking is on this case. All three of these factors, linoleum, paint, carpet, are pretty black and white. The rules are the rules. So when we have ranges of things, as for example, when we have ranges, that's to keep the hearing examiner kind of in check, to kind of say, hey, here's your starting base, kind of look at these numbers. So I look at a range as like, as Mr. Mers just said, explained about how there's a lower end and a higher end. So on an issue like this where it's just black and white, I'm going to start right in the middle, because that's not the higher end, that's not the lower end. The rule is every 7 years, except for like very extreme cases where they've protected the stuff for years, nobody's lived in it. So to me, I'm going to start the ranges all in the middle. And like staff, I think correctly points out that the linoleum is exceedingly bad. It's not just bad, it's not just old, it's actually causing problems. It's not sufficient, even in it's not whole, complete. So I do agree that on that one, I would accept staff's number for that. I think they said the 80th%. I didn't do the percentage on that one. But otherwise, on the other ones, I would subtract the difference between the high and the low and then go right in the middle. So for example, and I haven't done the math with the new numbers, but let's just take the 42 to 127, which I believe is the carpet. Paint. So you do 127 minus 42. That comes out to 84.50. You divide that by 2, and you subtract that from the top. So that's where I would fall on that one. Like I said, I would agree with staff on the linoleum. And that's how I look at this situation. If this isn't a situation where we have to put too much thought into what the quality or what the impact is, because it's just a basic, I mean, I'm going to feel much different if I walk into a brand new apartment and I see brand new carpet. That doesn't mean that if the same exact apartment had old carpet, I would be okay with just paying rent $20 less or $40 less. Like, it would change the whole picture of how I would look at that apartment. Some people more than others, but we shouldn't just, as he said, it's almost insulting that he got the minimum just automatically, just because this is a case where nobody objected to what his testimony was. It's pretty black and white to me.
Thank you. Who would like to go next? Commissioner Copeland, I see your hand. And then we'll go to Commissioner Topchin after.
Okay, thank you, Chair. I am in the same line of thinking as Commissioner Kerpes. I agree with staff that the linoleum, there's no doubt it's bad, it's damaged, it's in very bad shape. It is a quality of life issue if you're tripping over it, certainly. And the evidence was clear in the record about that. But as far as the carpet, I feel that the reduction should also be higher. I mean, if it were a situation of, I have carpet in one room in my apartment, that's 20% of it, it's not stained, it's not, it's 7 years, so it should be replaced, maybe that would be on the lower end of it. But when you're talking about 80% or whatever of your living space is stained, worn, I don't think that merits the lowest amount, as it is here in the record. As far as the paint, there's no question it's outside of the maintenance standard as well. That's something we don't have, the physical evidence of, as far as, I would say it would be at the high end if it had water stains or mold or something like, or peeling or something like that. But I also do not think that should be at the very bottom either. So my line of thinking right now is more in agreement with Commissioner Kerpes and his comments. Thank you, Chair.
Commissioner Topchin.
Thank you, Chair. I'll try to be brief. I'm in agreement with the fellow commissioners who spoke before me regarding the changing the amounts of the rent reduction. And I would say the basis for, my support for that would be the absence of any justification by the examiner pretty much justifying the lower end of the ranges. So this is very subjective, as the legal counsel explained. Anytime we deal with a rent reduction, it is always a subjective decision. I may look into one number, the other commissioners may look into another number, so it's very hard to come up with something that would be reasonable, right? So we don't talk about fairness here. So what is reasonable and what is balanced? And I would agree with Commissioners Kerpes and Copeland, kind of a position to recommend a higher amount. We're not going to go based on, because the examiner used a lower amount, a lower end, so now because of that, we're going to move to the higher end. Maybe the examiner had the reason to use the lower end of the suggested guidelines, but that was not explained in the analysis and the decision of the hearing examiner. So that gives me basically a window of opportunity to recommend a higher amount, and I think that is reasonable and that is justified and balanced, instead of considering other factors such as a rent level for this unit or some other factors. I would definitely go based on something in between, as Commissioner Kerpes recommended the formula. So clearly the fact that these services are not up to code, and that's why the examiner gave the rent reduction. And I sincerely believe that the reduced services significantly impacted the quality of the tenant's life and the health, convenience, and comfort. And therefore, I don't believe that the lower end of the amounts determined by the examiner will be justifiable. So I'm prepared to look into the higher numbers. Thank you.
Thank you. Commissioner Goldman?
So I also agree with Commissioner Kirby's about that middle ground amount. And, I think if you look at carpet that hasn't been replaced and painting and it is not up to standards, if you walked in to that apartment, as he said, as a brand new apartment looking to rent it, you would look at it very differently. You wouldn't want to pay that same value. So I think that's definitely something to consider. And I support staff's decision with the linoleum, and because that is a fairly significant inconvenience there. And I would put the others more in the middle rather than at the low end.
Thank you, Vice Chair Rory.
I think I would probably support a motion to remand the entire decision as to all three issues and let the hearing examiner kind of reassess what to do with the carpet, the linoleum, and the painting based on these conversations that we're having. If you guys want to get more specific about numbers that should be assigned, I would want to hear more deliberation about that, but a remand back on all three issues in line with what we've discussed would probably be something I would support. One of the things, because I think it bears on this, the next appeal we're going to hear as well, which is for the same property, so it's more of a process issue, or at least a factor issue, is I think the hearing examiner should take into account the time which the service should have been restored and hasn't been restored. So if it's, the 4-month or the 4-year for interior painting had just expired, maybe that is an issue that the hearing examiner would take into account and say, I'm going to go on the lower end of the range. I actually, on that factor alone, for Commissioner Kirby's sake, I don't come in at the middle if I'm just looking at the factor of how delinquent has the service not been restored. If it's just been a short period of time since it should have been restored, I don't start at the middle. I would come in at the low end. But I would take into account the other factors, which is how bad is it? Are there a lot of stains or other things? That's a separate issue. But just on the amount of time that's passed and it should have been restored and hasn't, I think it's important for the hearing examiner to be able to come in on the low end. For the interior painting here, it seems like there was almost 2 4-year periods in which it had been painted, because in the hearing application on page 42 of the packet, it says the painting has not been done since August of 2017. So for an appeal that happens in 2024, that's almost, 2 full years after, or 2 periods. It should have been done in 2021, and it hadn't been done in 2024. So I can come and see why painting probably should be in the middle there in terms of the range. For the carpeting and the linoleum, the carpeting, I guess, was only in 2017 it had been replaced. So for 2024, it actually hadn't been expired for that long. Now, obviously, there seems to have been issues with the stains and things, so I can see why the hearing examiner maybe should take that more into account if that's what this body thinks. But on the carpeting itself and the linoleum, I guess, in the kitchen and the master, it had been replaced not that long, 7 years before the hearing. There was linoleum in the kitchen, which was 2010, and I guess there's a little discrepancy here in the records, so the hearing examiner can take that into effect too. But I do think that the amount of time that's passed since the service hasn't been restored or should have been restored is a legit factor. That's what I think the hearing examiner probably skewed towards here and what they initially decided, and I can understand that. And if this body then says, well, we want you to consider some of these other factors as well, I would support a remand on that. Last thing I'll say on this, which I found it kind of hard on the pictures we had and the evidence we had, and to the point of the tenant, you know, two-dimensional pictures are really hard to encapsulate what's going on in the interior of a two-bedroom, two-bathroom apartment. And on that alone, I found it hard to say there's substantial evidence one way or the other, because I was just looking at these black and white pictures going, this hardly tells me what's going on. And so it's really hard to then support a hearing examiner's decision one way or the other. But there was anecdotal email evidence and other things in the record that could get us and get me to a remand motion on all three issues.
Thank you. I echo Commissioner Kirby's comments, as have most of my colleagues. For me, it comes down to, in heeding the city attorney's advice on speaking to into the factors to consider, I believe I have a hard time with that word, but the comfort of living in your home. How about that? I think you all know what I'm trying to say. That word's tough for me. Especially since I just got Invisalign, so I feel like I'm slurring these days, so forgive me. I'm embarrassed, so. But getting back to serious business, the comfort and of living in your home, I think that one of the factors to consider is the cumulative effect of not having your carpet replaced, plus not having your linoleum replaced, plus not having it painted. If it was any one of those issues, I would be leaning a little bit more towards the lower end on that one, because it's just one thing. Maybe there's a dispute between the landlord and the tenant as to whether it actually needs to be replaced or not. But when it's all of those factors together, it comes in as a bigger issue, as they're all cumulative. So I think that speaks to the habitability. Not going to try it again. You all know what I'm trying to say. I also think that that one reason that we should look at the actual numbers as opposed to remand is that although it's a minor error, it is still a clear error on the part of the hearing examiner by using the wrong valuation guidelines. So generally our question is, would a reasonable person make the same decision and with the information in front of them? And it's just the hearing examiner used the wrong numbers. And even though it's only off by a few dollars, there is a mistake there, and there is no justification for those numbers. So I think that forces us to then look at those numbers. And because of that, I would lean very much to what Commissioner Kirby was saying. I figured out the medians as paint $84.50, carpet $114, and then the linoleum at $36. But I could be persuaded to go to the 40 on the linoleum as well. Okay. 41 to 123 on paint. I think the midway point's 84.50. Carpet 62 to 166. 114 seems like it's in the middle. And linoleum 19 to 53. I think 36 in the middle. I'm just going right in the middle of those two numbers. Yeah.
So I came with 70. The middle one. It would be the paint. No, it would be which one's more expensive? It's 64 to 114. Maybe I screwed up the math, but we should just double check the numbers.
171 on carpeting, 64 to 171.
Oh, that was my problem. And then, so assuming your math is right, yeah, I would go with those numbers.
I'm more than happy to, not my strong point, so I'm more than happy to have anyone double check my math. But numbers I came up to are 84.50, 114, and 36, which is pretty close to the 40 that staff recommends on linoleum.
Yeah, I came up to $35, so yeah.
Yeah.
Can I...
I'm not suggesting those numbers. I just thought that was a good starting point for a conversation.
Oh, no, I'm fine with those numbers. I just wasn't sure if you were done. I would just say a couple comments about...
Please.
The time, I disagree about the time in terms of, and the hearing examiner did talk about that. I do understand, and maybe in, well, I'll tell you my situation, so why it wouldn't work in my situation. So I moved into my apartment in 2013, and it wasn't until 2024 that I asked for it to be repainted. the landlord never attempted to come in, but I never complained about it either. I didn't really want them in to paint it. So when I wrote my letter to ask them to paint it, they actually ended up immediately painting it. But had I written my letter and they waited 60, 90, 100 days, if we were to start taking into time frames, that would, you'd have to calculate all that. Like, you don't know if I voluntarily kept them away for those years, or if, does that make sense? So you're saying every 4 years or every 7 years when they're supposed to come in and do it, if they wait 8 years or 9 years, it should be more? Is that you were putting more weight on those lengths of time? Is that correct?
Yeah, I think that should just be a factor that the hearing examiner could consider. And your anecdotal experience was not in the record. I was
Yeah, no, I was just
evaluating.
giving you an example of why that's one of the reasons why I wouldn't support that, because again, as the tenant so
But under your
explained.
scenario, I would think you would probably be more in the middle, because you had lived there since, in your scenario, 2000 whatever 13, and you didn't ask for anything until 2024 whatever. So had you not gotten what you wanted, I think that multiple periods would have lapsed for, say, interior painting, and you should be entitled to a median amount at that point. That would be my suggestion. But I do think that what we want to be careful is that if a landlord doesn't do the interior painting to 4 years and the day, and some time passes before the next painting occurs, that doesn't automatically jump them to the middle of the median of the scale. That's just on that issue alone. Okay, you know, there's been some period where it should have been done, but it hasn't. I think that's a legit factor and I think that's what the hearing examiner probably did here, which is why their numbers are low. And I was trying to make it understood, you know.
Yeah.
I had a question for the chair, though, and I didn't mean to.
Let me just,
More
yeah,
everything.
so we disagree on that. But I wanted to point out that I did appreciate how clear and concise and, in my opinion, correct the tenant was about how, yes, absolutely, this is not a penalty, but it should not also be an incentive either. And I think that was a very good argument. I fear that if we take that time and we start looking at time, you are starting to punish versus taking the value of what's missing. And so we just want to be careful of that as well. But I think we'll just agree to disagree on the time thing.
So my question is, why don't you want to have the hearing examiner reassess, especially in light of the schedule being wrong, instead of us deciding it tonight? What's your thoughts on why specifically you wouldn't want it to go back to the hearing examiner to look at the new schedule, look at all of our comments, versus us tonight saying what the amounts are going to be? That's where I get a little stuck, because I feel like that's substituting my judgment for someone who's more qualified than me to look into all these factors again in light of our comments tonight.
Chair, may I
Please.
make one correction before you answer that? I just want to correct the language. The valuation numbers that were used weren't in error, since they're just a guideline. So the guidelines are updated, but error is just the wrong word, because they could have put it at 0 and it wouldn't be an error. It was.
And to clarify that comment, I meant their reference to the valuation guidelines, their reference to that, not the numbers they landed on.
Sure.
The numbers they landed on are
I
not
understand what you're
justified.
saying.
It was that the reference that they used, they referenced the wrong valuation guidelines. That would be
The outdated
error.
outdated guidelines. Correct.
So it's just an error of reference, not an error in judgment.
Understood. I just
That's-
want to clarify that for the record, that
I appreciate
if
that. I
it
think
goes
we've-
up, it's not an error under any of our codes or anything like that. Since they're simply guidelines, they can't be technically an error. But yes, they reference the prior years, which I guess could be an error.
Yeah, the reference to the existing guidelines, yeah. So for me, I feel like since there's no justification for the numbers, if we took staff's recommendation, I think it would stand to reason, I'm not putting words into staff's mouth, but I think it would stand to reason that we would correct the number on both paint and carpeting as well, to at least get it to the bottom of the valuation guidelines. That seems to be within the spirit of the staff recommendation. Looking to see if they shake their heads no and correct me on this. They're shaking their heads yes. So I think we would be correcting the numbers anyway if we just took staff's recommendation. So I think that the midpoint on linoleum is within a couple of dollars of what staff's recommendation is. So it's just a matter, I think, for this commission, do we remand to have this whole conversation, or do we go along with the spirit of staff's recommendation on linoleum to come up with a number for carpeting and paint as well? And I think the commission is capable of doing that. And again, my rationale is that it is a cumulative effect, and it's not punishment, but the habitability, I think I got it, of the unit is impacted by all of these things. And so I think that's where I come to this commission being capable of making that decision tonight. And I would not be angry with a remand if that was the will of the commission, but I don't see that. So I think I would like to land on some good numbers if that's the will of the commission. And I recognize, trying to answer the vice chair's question, and I think that I have how I got to that decision. And I recognize Commissioner Copeland because I see your hand. And then Commissioner Topshin again.
Thank you, Chair. I just wanted briefly with Commissioner Kerpes, we're talking about a timeline. If we give that kind of weight to, well, it's only been 4 months or it's only been 6 months, we don't then, so we'll give a lower amount. We don't then allow the tenant to come back 2 years later or 3 years later and say, hey, they still haven't done it, I want more money. You know, so I don't think that should be given a lot of weight, because 6 months from now, maybe it's still not done, you know, and as you say, it shouldn't be punitive, but I don't think the greatest weight should be given to, this is recently outside of the timeline, perhaps. And I think we can come up with numbers without a remand that perhaps we all think are more in line or fair. That's just my opinion, Chair.
Of course. I want to go to Commissioner Topshin. I want to also point out really quickly one thought that I missed in answering the question is, the other part is, if it was a studio apartment with one small piece of carpet, let's say in one area, I think that's where we go with lower numbers, but a 2-bedroom where it's a bunch of rooms that are carpeted, I think that's where why I'm comfortable with like the median. Sorry, I didn't get that in my original comments, but I want to go to Commissioner Topshin and then Commissioner
Just
Copeland.
very quickly, and Commissioner Copeland, basically, you read my mind. That's what I was going to say. The timing for how long the service, not the service, the condition were in bad shape, and for when the tenant can apply and receive higher or lower amount of the rent reduction. It's really, the timing is irrelevant, because we've had cases when the tenants applied for a rent decrease years after the service supposed to be, let's say the building's supposed to be repainted or recarpeted, and the rent reduction was not at the higher end and could have been like lower or somewhere in between. That is all based on the how the examiner will read the evidence and look into the degree to which that condition was deteriorated, and the level of the habitability condition of the whole thing. So I don't think the time would really play a role, and because of that, I don't think that this is a remand issue. And since it seems like, you know, the majority of the commission is in agreement to look into the higher numbers now, we can do it now, and using the recommendation given by Commissioner Kerpes and others. So I don't think we need to waste anybody's time and send it back to the examiner and waste all the resources when this can be done today and now. Thank you.
Thank you. Commissioner Goldman?
Yeah, so I was wondering what does happen, and Commissioner Copeland sort of answered that for me. If so, the tenant gets their reduction, and then in the meantime, they're still trying to get the landlord to paint or replace carpet or whatever the issue is, and the landlord's still not doing it. There is no other recourse. It sounds like, or no other way to kind of prompt the landlord to to comply. Is that correct?
I was not totally listening. Sorry. If you'll repeat that.
Yeah, so I was just wondering, so say that a tenant gets their reduction for, whatever it is, carpet paint.
At the hearing level?
Yeah, so, and then, months go by and it continues, they're still asking the landlord, hey, these are supposed to be taken care of every 4 or 7 years. There's no other action the tenant can take. Is that correct?
So yes, there's no mechanism to force a landlord to fix the issues where a rent reduction is put in place by the rent commission. Some of these issues do fall under code compliance issues, not all of them. If that is the case, there could be a code case. If it gets really severe, the code issues, it could go to the city prosecutor, it could go to the city attorney's office to initiate, actions in court. That's more severe. But in general, there's no mechanism for the tenant to force them to do those things. That is why there is a rent reduction in place.
Yeah, so I think in light of that, that's where I get to, if we say, oh, well, it's only lapsed, a few months, then the tenant could be living with this for years to come. So I feel like to that end, I don't know that I would take that time into consideration. I would look at the the evidence and the state of things, and assuming that reduction is in place because they might be living in those conditions for months, years, potentially.
I have a follow-up to that. Isn't there a place for certain conditions where the tenant can get permission to fix it themselves?
They can do that, but the question was, I took it as, what can you do to the landlord to get them to comply? But yes, there are certain actions they can take where they fix it themselves.
There's a process for that they can contact the city rent stabilization department to find out how they can do that and get this resolved. Because, at the end of the day, we don't want to just tell a tenant, sorry, you're out of luck, you have to live in not that applies here, but in an extreme situation, you have to live in a horrible place that you're not comfortable in. There are remedies beyond just the rent reduction if it continues.
Yes, I would just note that
I'm trying to talk in real big picture because I don't want it to apply specifics.
Yeah, and I want to direct people back to this. Those aren't relevant to this case, and what we shouldn't base the amounts on the potential for future harm and how much, because you're tasked with looking at whether the record supports those decisions. The record stops at the hearing, so anything past that is not really a factor that you should be looking at and doing the valuations.
Okay.
So
for us tonight, what is the value of the carpet? What is the value of the paint? And what is the value of the
I was going to say, I hope based on this robust conversation, you're getting to a conclusion, and to help you get there when you're discussing is not only do you have to decide the actual amount that you want, but when you affirm a hearing examiner's decision, the resolution can be very short because you're adopting all of the findings made in the underlying decision. When you are modifying it, like you sound like you might tonight for parts of it, you have to make additional findings. So it has to be a little more robust of a resolution. So if in the draft resolution, you'll notice when I changed the amount for the linoleum, I spoke to several of the factors in the guidelines. I will need you to point to one or two of those factors that you think justify either why you're going up or several of the factors that justify why you're not going to the higher end of the range. You can do it from either direction, but we need some collective choice on several of those factors.
I would suggest that the size of the apartment being a 2-bedroom apartment and that there being an extensive amount of linoleum carpet and paint justifies higher than the minimum. I would justify raising it because the valuation guidelines, the numbers for all three came in below the valuation guidelines, so we're going to go within the valuation guidelines as they were at the time this was applied. I would suggest that there is evidence of staining, even in the really black and white photos on the carpet, justifying a need for a change there. I would fully support staff's justification on the linoleum, and I think that might help us get to that point.
Yes, and I appreciate all of those. Those all would go into the other factors deemed relevant. I would say it's most appropriate to look at the ones that are already written in the regulations and just say the numbers. We don't have to go that deeply. If you want to, you're welcome to. It's your commission. But if you just say the extent that it affects the tenant is an issue that you think justifies the hire, that's the number one on the list. You can say number one.
I was trying to make it more complicated for everybody.
Yes, and
I'm trying. Let's make it easy because I think we're all on the same page. Let me see what.
Actually, can I make it try? Chair?
Why don't you try to make a motion? Yeah.
I want to make it real easy. I want to make it that what we're doing is what I stated from the very beginning. This is a black and white issue. This is not something we have to spend a lot of time thinking about. The range is a high and low, and we've already given justifications for what makes you a high dollar amount, what makes you a low dollar amount. With a few exceptions, these pretty much fall right in the middle. And so that's what I'm stating, that the hearing examiner erred in the way they applied the range. They give no justification for the lowering it from what should be the standard. I think we should adopt word for word almost the staff's amount. It just happens to be that it still falls. That's what I'm trying to say. Falls above the amount that I would have went with if you look at that middle range number. So, and I think it's justified. So we don't need to change any wording there, I don't believe, for the justifications. And then if we did go into what you want to talk about the stains and all that stuff, to me, it just justifies in my mind that we're making the right decision. But if we wanted to actually add that in there, then I think you should also add on a few dollars because it pushes you to the upper end of the amount. Just so we're all making logical sense in our evaluation, our logic in this.
Yeah, and Chair, if I may, so I hear what you said, and I agree with everything you said, but I think what I hear is the legal counsel wants to hear from us reliance on the rent adjustment regulations and to use the specific provisions or parts of that regulations and for the record at least, because we all explained why we are modifying these amounts and we all justified. But as for the record, I think I would recommend that we use number and the factors in the Rent Adjustment Commission regulations, factors number 1, 2, 3, 5, and 7. These are, to me, these are the relevant ones based on our discussion on modification. So I don't want to read them. I think everybody has those numbers. So, and if you agree or if you would add anything, thank you.
I think we're there. If the city attorney feels confident that we've justified.
Yes. So I will read what I have as a summary, and then if that is how you see fit for the. Did we have a motion yet? I don't think we have made a motion.
Move what you're about to read.
You're going to make a motion based on what I say if it is the right stuff. Okay, I got you.
I'll second.
Why don't we hear from the city
has a
attorney?
dollar amount, don't you?
I do
Did
have
you-
some dollar amounts, and I messed one of them up. I just double checked it. But
Yes. So from the draft resolution, we are taking out that we being the commission, agree with the amounts as to the paint and the carpet, but you agree with the findings that the paint, carpet, and linoleum were reduction in services that warrant a rent reduction. And so for all three, the linoleum, paint, and carpet, they're going to have a change in the amount. We're doing nothing to the draft resolution as to the linoleum issue and amount, but we are changing the paint and the carpet. And the paint and the carpet will match the same style of the draft resolution of why we're changing it. But it will say that the reasons are the guidelines 1, 2, 3, 5, and 7 of 60041, substantive grounds for downward rent adjustments. And all I need from you fine folks are the amounts that you believe are the appropriate amounts. I wrote down, and I could be wrong, paint at 8450 and carpet at 114.
I mistook the, I used the wrong numbers too when I did the 114 on the carpeting. So I think it's 11750.
Yeah, I did the math on my own, and I saw that, but
I used the old numbers as well, so it's an easy mistake to make. So 8450, 11750, and are we sticking with the 40, or are we considering the halfway point of 36 on linoleum?
It's 40.
The 40, which comes to a total of 242.
242 and 50 cents?
No, because 8450 and 11750
Oh, is there 11750?
and 40,
Got
so
it.
242.
So the paint is 8450, the carpet is 117 and 50 cents, and the linoleum stays at 40.00. Does that make sense to everyone? If there's a motion made on that, you know what you're voting on? And it would be to affirm in part and modify in part would be the title. And I heard
Yes,
Commissioner
that's
I
the
hear a
motion.
motion from Commissioner Kirby to that effect, and I believe Commissioner
I'll
Copeland
second.
was prepared to second that.
Yes, Chair, thank you.
Any additional questions or concerns? Then I would ask our secretary to take roll on that motion.
Commissioner Copeland,
Aye.
Commissioner Goldman,
Aye.
Commissioner Kirby,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Rory,
I don't think it's black and white, but aye.
Chair Bass.
Aye. That motion carries. So the parties know that there's something to read here. If the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rsd@weho.org, or you can request an in-person appointment online at weho.org under the services menu. We now have a second appeal. Is this something the commissioner would like to take up immediately, or would you like a break? We will take about a 5-minute break at this point in time.
Is it inappropriate to thank you?
It would be inappropriate because you're a party on the next one, so let's withhold any conversation with the commission until after the meeting. No, if at all. They give you a gavel for a reason, so. I'd like to call the meeting back to order, being a little silly this evening. We now have a second appeal on, this will proceed, since it's essentially the same parties. You all know the rules, I won't really repeat them, but I want to turn to our legal counsel for our next appeal, which is D5000, same address, but a different apartment number, I believe. So we'll go to that.
Good evening again. Kellen Martz, legal counsel of the Rent Stabilization Commission. D-5000 is the appeal before you at 1301 Havenhurst Drive. You'll note, as the chair did, this is a different unit number. That's because that was what it was originally filed under. The tenant in this case, Mr. Rusnow, is a common area tenant, so he has standing to appeal, but he obviously is not at 217 unless he moved during this process. But I believe he's still at his same unit, so that is why they look a little bit differently there. In this case, this is an appeal that arises from a hearing examiner's decision granting a rent reduction related to the on-site manager requirement. Staff recommends affirming the decision and modifying the decision in parts. This was a rent reduction application where the hearing took place in February of 2025. The filing tenant, Mr. Deason? Correct. Appeared, as well as Mr. Rusnow at the hearing. The landlord did not appear at that hearing. The two tenants testified about the resident manager resigning and that there was no resident manager replacement by the end of the year. The building, per their testimony, is 40 units. The hearing examiner issued a decision in March of 2025 granting a rent reduction for all common area tenants in the amount of $14 per month each. In this is a common area issue. There were no opt-out forms received. The decision stated the reasoning for awarding $14, the lowest amount on the guidelines. The decision stated that it was because there was no evidence of any significant negative impact due to the lack of the resident manager, and because the resident manager position had just been vacant for a short amount of time. Tenant Michael Rusnow, Unit 114, has appealed, arguing that the amount is too low. And again, as an affected party, he is allowed to appeal on behalf of himself and others in the building. Mr. Rusnow states that the absence of the on-site manager is a serious failure to provide a housing service for a 40-unit building, and believes that the hearing examiner improperly minimized the impact, even though it is a short duration of time without the the resident manager in place. The hearing examiner also found that there were an absence of specific incidents that did not come about, so there was no major issues. Mr. Rusnow takes issue with that as well. The question before you tonight is there substantial evidence to reasonably support the hearing examiner's decision regarding the on-site resident manager? Hopefully, much of the discussion from last appeal can carry over to this one. It is similar issues that you're looking at. Staff believes here that the hearing examiner did not err, and there is substantial evidence in the record to support the decision and the findings that this is a reduction in services. However, like the last appeal, staff believes that the amount is too low. Staff believes it should be increased from $14 to $35 for all affected tenants. The range is $14 to $116. There were two rationales, which I've already explained in the decision, as to why the hearing examiner felt that the $14 amount was correct. And here staff agrees that the amount of time is an important factor and that there have been no major issues in the building. However, quality of life, safety, and convenience are issues that staff believes warrants an increase, and also the market value of what a resident manager is worth in West Hollywood. And so for those grounds, staff believes that the amount should be increased to $35 for all of the tenants in the building. And that concludes my report.
Thank you very much. Do we have any questions for staff at this time? Commissioner Kerpes?
this might be irrelevant, but I'm still going to ask it. Why is this landlord not being prosecuted? This is against state law, city law. They can't just operate a 40-unit building without a resident manager.
That's,
You can say it's irrelevant if you want.
it is, but going to prosecute someone generally rises higher than a lack of a resident manager for a relatively short amount of time. I think one factor that the city prosecutor would look at is that there is a process playing out here, and so that decision is on hold. So there is no order to have that, even though there are separate state laws on that. So I think there's a multitude of factors that go into play there.
Thank you. I don't have a question. I just want to suggest, because I brought it up in the last appeal, that because of the last appeal having the wrong valuation guidelines, I checked and these appear to be correct to me, and it's a different hearing examiner, different hearing, and so we're not confused with the issue I brought up on the last appeal. And Commissioner,
A real quick question, the unit threshold for having an on-site resident manager?
16. Correct.
Okay, and we're talking about a 40 unit building here.
That is right.
thank you. Any additional questions? Then we will turn to Mr. Rusnow, the appellant. Again, we know who you are, but for the record, please state your name, city of residence, and how you would like to divide your time as you did before.
Well, I'd like to double my time because you enjoyed it so much. But Michael Rusnow, 1301 Havenhurst. And just before the clock starts, I just want to let you know I'm able to do this, but Richard Deason, who applied, had a very personal matter happen when the time for applying was to appeal. So since I was eligible, that's why I'm the one standing here and not Richard. Okay? Here we go. Ready, Randy?
Mr. Rusnow, just before you begin, there is an opportunity for public comment that people can provide public comment in addition to the appellant's testimony. So that opportunity will be people will be called on at that point in time. And just tell us how you'd like to divide your time before you begin.
I'm just going to talk, and I think
before?
Having rehearsed, I think we'll have rebuttal time.
Thank you very much.
Ready?
Please proceed.
Okay. I've been a tenant at 1301 Havenhurst 35 years. Until last November, it's always had an on-site manager, starting with Philip, then Jose, then John, then Danny, then Richard, then a young couple who lasted a very short time, can't remember their names, then Judy, then Tim, then Parissa, then Jamie, then another Jose, then Kendra, and finally Johnny, who resigned after a dispute with management. So this list indicates tenants were served by an on-site manager till the past 5 months. We duly noted there was no manager by email to LLFO Properties last November, which never replied. Nor did anyone from LLFO or the new owner, 88 Place Acquisitions, a part owner when LLFO was involved, show up at the rent reduction hearing Richard Deason and I attended February 10th. There is thus a pattern of ignoring our concerns since management has gone through tumult. Well, that's not part of our appeal. The law, the hearing examiner, Elio Palacios, and the staff report clearly agree we are in the right. These details help commissioners factor in why management acted this way. Also, both Mr. Palacios and staff report seem to lessen our grievance, surmising tenants didn't undergo trauma from the absence of a manager and the December date Richard Deason filed his application. Neither addressed the urgency to Los Angeles area residents when fires threatened our neighborhood on January 8th. Partial landlord Bob Assel called that day to warn about possible evacuation. But I didn't recognize his number and he left no message, so due to spam calls, I didn't pick up. He later emailed me, but an on-site manager could have swiftly notified me. Many of us were glued to TVs wondering whether to flee. Some actually started packing their cars until it was clear the fires weren't close enough. So it was specious the fire emergency wasn't mentioned in either report, where staff agreed with the hearing examiner who said, the minimum reduction is warranted because there was no evidence of any significant negative impact due to the lack of a resident manager. This, even by the February 10th hearing, when Mr. Palacios was certainly aware of the emergency, though they'd not occurred when Richard Deason filed, and the staff report made no mention of the fires even when written on March 12th. However, the staff report agreed with me that $14 was too low, recommending a bump to $35, still only 31% of guidelines maximum. Apart from major catastrophes, how does a manager affect our quality of life, safety, health, convenience, and comfort of the tenant? There are instances when a tenant is accidentally locked out, and in many instances, a manager can help. The manager is also able to accept packages if the tenant's not home and arranges an appropriate time, as minimum hours are prescribed by law, and or deal with emergencies when a tenant is out of town, as indicated in my March appeal, which I'm sure you read. Smoke alarms go off inside vacant units, and a manager with keys can help. They also have personal telephone text numbers of management and can instantly contact them, especially when problems occur on weekends when the office is closed. There's an emergency number for calamities, but many situations can't be solved that way, all of which affect the impact on the habitability of the rental unit, plus the prevailing market value of the housing service in question as a rental amenity. While rents of current tenants are not subject to market rates, the value of no on-site manager does subject tenants to a major loss of a long-held service to which, number 5 in the mandatory list says, the extent to which the tenants were led to rely upon the fact that the service would be provided. Please note, I attended your hearing D4955 on April 10th. What's of interest is the $55 amount originally decided for a manager issue in that much smaller building. Why was our 50% larger building lowballed, first grievously by the hearing examiner, but even with a slight bump by the staff report? We therefore request the rent reduction for no city-mandated manager be raised to at least $90, and I reserve the rest of my time for rebuttal or maybe a joke.
Thank you very much. Will our secretary, how much time does he have?
40 seconds.
Almost exact as last time.
I rehearse well.
Do any questions of the tenant this time from the commission? Commissioner Kerpes?
Yes. In your letter that you wrote for the appeal, you gave lots of examples of how having a manager on site is helpful and the services they provide. But I was puzzled by why you would include the situation with Johnny. When Johnny was there, you were away. I contacted him from abroad, asked him to remove he put notices on your door even though you weren't there. He didn't use good judgment. Obviously it was a situation where you had been gone for a while and things were piling up, but yet you had a manager. So it's things like this that would lead me to believe that when you did have a manager, it wasn't necessarily as good of service as one might think. So that would lower the value of what not having a manager would be. Does that make sense?
Well, yes, except if I can briefly reply and not risk my 40 seconds.
No, this is not your time.
Right. In point of fact, I was in Europe for a month, and I think it was on the island of Cyprus, and I mentioned in the letter that by a fluke of luck, I was checking my recordings of my TV, and I said, well, nothing's been recorded for a week. So one of my neighbors, and Kendra, actually...
No, I understand that.
So that one you understood.
You have that in there.
Okay, all right, so you understand that. With respect to the thing, Johnny insisted that he was specifically instructed to put notices on all the doors, and he didn't want to impact his service as manager. But when I let him know, hey, don't do that because thieves come into the building, or maybe delivery people, they will then know if there's millions of things on my door, they might say, hey, he's away, so maybe we'd better,
So you put that example in there to show how having a manager there removed those items.
Exactly, he did.
Okay.
And I thanked him for it, truly.
Thank you.
Thank you. Seeing no others, you have 40 seconds left for rebuttal, should you choose to take it, and we will move now. Thank you for your time, and we will move now to see if there is any public comment on this item.
Do you want me to do the rebuttal now or after?
No, I'm going to ask for public comment.
And then the rebuttal,
Yeah,
okay.
if there's anyone else in the room who would like to speak on this issue.
Yes, we do have 2 public commenters. Jalen Schoenfeld.
And I would just ask you to state your name, city of residence, and I believe we allow 3 minutes for public comment at this point.
Okay.
Is that correct, Madam Secretary?
That is correct.
Thank you.
Okay. Hello, I wrote everything down to make sure I got everything.
Just please introduce yourself by name and city of residence, and then you may
Okay.
proceed.
My name is Jalen Schoenfeld, and I am a resident of the city of West Hollywood, and I'm speaking on behalf of me and my wife. My wife is named Delina Rice. Back in January, I watched the fire coverage like everyone else did, and I saw the fire start in the Hollywood Hills, and it was very alarming. Then I received a text on my phone to prepare to evacuate. Then immediately after that was a text to evacuate now. I quickly began packing some necessities for myself and for my wife. My wife is permanently disabled and has mobility issues, so it added a little extra worry there. I was fearful of the possibility we would lose power and would not be able to exit the underground parking garage in time. I carefully helped my wife navigate the stairs down to my car, and thankfully we were able to exit the garage with no delays. Later, I saw that I and my neighbors had received an email about the fires from management, quote, strongly advising all tenants to be prepared to evacuate the building. And, quote, we are working to get the garage opened and keep it open in case power goes out, which wouldn't be necessary to work on getting it done if we had someone there. I just feel this is just one very clear example of why an on-site manager is needed. Secondly, there is an apartment in the building that had a fire alarm randomly going off. Months ago, our previous on-site manager, Johnny, could access the apartment with the master key and handle the matter. It happened multiple times after he had moved out and would continue for days. Of course, with all the fires in the area at the time, it was a bit jarring and unsettling to hear a fire alarm. An on-site manager would have been able to attend to the matter that day. I thought that I'd have more time to speak than I prepared, but I will just say that I've lived in this building for over 30 years, and I've never not had an on-site manager. And I think we really need one. Thank you for your time and your consideration.
Thank you very much. Our next public speaker.
Richard Deason.
And again, please introduce yourself by name and city of residence, and then you may begin.
Yes, I'm Richard Deason. I live at 1301 Havenhurst in apartment 217. I'm the original applicant for this hearing here in West Hollywood. There have been numerous incidents. I was kind of surprised at the original hearing official who said that there were no specific incidents that required things, because we've had quite a few incidents where when we had a manager, were quickly taken care of. The most important things I saw were, first of all, as has been indicated both by Michael and Jay Lynn, was that they have access to the master keys, so they can let tenants into their apartments if they're locked out, as Michael's indicated. They also can take care of emergency situations. I had a situation in my own apartment about a couple of years ago where the tank in my toilet, not the toilet itself, but the tank had an incident where a piece broke and it didn't have an overflow drain. So the tank started overflowing. Well, fortunately, I was at home at the time and I actually heard it and was able to turn off the water, but if I hadn't been there, the manager would have had to been called and come in, which she would have done. But if we don't have a manager, that could have gone on for hours and it would have flooded the apartment below me because I'm on the second floor. And as it was, it did quite a bit of damage to the apartment below. But if I hadn't been there and it continued going, it could have done structural damage to the building as well as to the foundation of the building. So that would have been one thing that needed to be addressed. And to call the manager we now have, who's actually located in Beverly Hills, and taking the time to either get a plumber over there or them to get over there to turn off the water would have caused considerable damage, as you can imagine. The second thing that I think is an important situation is access to maintenance people. We obviously have the normal maintenance people, like the cleaners that clean the common areas and the people that do the pool cleaning and the gardeners and so forth and so on. And the manager supervises these people and makes sure they get things done and gives them access to the building and so forth, and make sure that things are done and that the security is maintained at the same time so that other people don't get in unauthorized. They also maintain a list of people that service people that we need for special situations like plumbers or special people to come in and do special things, you know, carpenters or handymen and stuff like that. And it's hard for us as individual tenants to maintain those things and do those things for ourselves, or we have to call the management company in Beverly Hills and try to get them to get contact with these people when we need them. And then there's also the issue of surveillance. And we've had an issue several times of homeless people that we have one unit on the front of the building that has a private patio that's surrounded by a high fence. It's about
That's your time.
5 feet tall with a hedge around it. And we've had people with
Mr. Deacon, you can finish this thought, but your time has expired.
Oh, I'm sorry. Okay.
Thank you. Just have to keep to the rules on that.
Sure.
Thank you very much for your time. Do we have any other public speakers?
Not at this time.
Okay, so now, Mr. Rustnow, you have the opportunity for 40 seconds to provide rebuttal or further thoughts.
It's taking me 10 seconds just to walk up here. Again, Michael Rustnow again, there's nothing in the law requiring a manager, specifically what a manager does, except for the mandated hours. There's nothing about catastrophes that must be present all the time, plus the fact that you're supposed to file within 30 days because you want to get your thing in as soon as possible, and to penalize us because at that point there hadn't been a catastrophe, as there clearly was in the months following, during the hearings and during the staff report, that they could have certainly referenced, gee, wouldn't a manager have been helpful? Plus, opening that garage is difficult when there's no electricity, and a manager knows how to do it. It's a complicated thing. So anyway, you've heard what I've had to say. If you have any more questions, I'm here, and it's free. Thanks.
You could stay there just for 1 second. Are there any questions from the commissioners? Then never mind, I had you come back for
I'm
no
so
reason.
hurt, but I have a tape to play you later. Thank you.
Appreciate your time. Our secretary is just checking to see if there's additional public comment. I did not call on the landlord, but the landlord is the same person from before. I apologize for going out of order, but I want to make sure the record shows I'm calling on the landlord now and seeing no one identifying to speak. So there is no landlord to address this issue. So with that, I will close the public hearing. And I will turn to my colleagues to see if there are questions or if we would like to turn to deliberation at this point in time. Commissioner Topchin, please.
Thank you, Chair. Well, in the prior appeal, it was interesting that there was no justification. There was lack of justification for the lower rent reductions for those items that we discussed. In this case, in this appeal, it is surprising the justification that the examiner issued, which quote, the minimum reduction is warranted because there was no evidence of any significant negative impact due to the lack of resident manager and because the manager position has been vacant since November 2024 only, end of quote. So this is truly surprising to me. So do we really need to wait to see how badly the impact would be on the resident, on the tenants, on the building, the lack of resident manager, so to warrant a higher rent reduction? So this was the justification for the lower end of the reduction, although the correct part is that the rent reduction should be warranted because of the lack of the service. But the justification for the actual amount, which is the lower end, $14, is just surprising to me. And not to say that the actual ranges that starts with $14, that's already something that really bothers me, but that's in the regulations and we can discuss it maybe sometime in the future. How can we kind of increase the lower end for this service? The reason why I'm saying this particular service is something is very important and significant for the residents of West Hollywood. And this was actually discussed, I think, by the City Council if I believe in 2024 or 2023, the City Council heard the specific matter on regarding the on-site managers, and they pretty much expressed their concerns of a lack of on-site resident manager in some of the buildings, and they believe this is a severe violation. Not to mention, this is not just a violation of the city law, West Hollywood Municipal Code, but it's also a violation of the state law, and could be some other laws, right? So fire code, etc. So this is a very significant service that we want to make sure that the tenants in the buildings with 16 units or more have on-site managers. So now, based on that, I definitely agree with staff's recommendation to modify the amount, but I, just like in the other case before, I believe the amount has to be significantly higher than what is recommended in staff's recommendation. So I'm open to hear from fellow commissioners on the amounts. Thank you.
Thank you, Commissioner Topchin. Commissioner Copeland?
Okay, thank you, Chair. I agree with staff also that the reduction amount was too low for the loss of a resident manager, but I also feel, as my fellow commissioner here does, that the recommended adjustment is perhaps still too low. I mean, surely it's safety, quality of life, and convenience. It's a security issue, actually, not to have someone there with an eye on a building that has 40 units in it. And it's not just even security issues, that we shouldn't wait for something serious to happen, you know, before we award something higher than the bare minimum. But the regular issues that would normally come up on a regular basis that a manager would handle, that the tenant should not be left, you know, to fend with, like there's a leak somewhere, there's a light bulb out on the stairs, the pool's making a noise, you know, somebody didn't show up to do maintenance, the coin slot is jammed in the laundry room. You know, these are things that happen on a regular basis that affect the tenants, and they shouldn't have to either try to fix it themselves or wait for days or however long to get something addressed, whereas if a manager was on site, that would be some immediate relief in the most part. So I just feel that it should be, as Commissioner Topchin said, in the higher range than this, particularly with a building that size.
Thank you.
Thank you, Chair.
I'm sorry. Thank you. Any additional comments? I have the range as 14 to 116, with the halfway point being $65, since I was doing the math earlier. Additional comments?
Are we deliberating? Or?
Yeah.
For this particular loss of service, I feel like the size of the building matters, the number of units. If this had been a 17 or 18 unit building and they didn't have a resident manager, maybe that would factor into a lower amount, but 40 is a big building. It needs an on-site manager. So that immediately makes me, you know, think that the severity of the loss here is more substantial and certainly justifies staff's recommendation, or I will reserve my vote on what number you guys want to maybe throw out for something even higher, which seems like the trend. What I wanted to say, for maybe the sake of the hearing examiner who's looking at this, I empathize a little bit to the extent of, especially in the law, you're trained not to think of the hypothetical things that could arise that maybe would justify a number. You're trained more to think of what are the actual issues of how it's impacted. And I think maybe what happened here was it had only been a month since the loss of the previous manager, and the hearing examiner just had a very short amount of window to observe, and the evidence that came in at that point might have been limited. And they were reluctant to go down the path of, well, what about this and what about that? So I can kind of empathize a little bit with what the hearing examiner did, and I want to state that because I don't think these are easy issues to be deciding on the front line there. But based on the stuff that was in the record, it's, you know, even just the beeping of the fire, and some of the gate issues, there were immediately problems with the lack of a on-site manager, even in that short period. And this was a 40-unit building. The requirement is for a minimum of 16 units. So I'm amenable certainly to supporting staff's recommendation, and likely support an increased amount depending on what you guys come out as a number.
Commissioner Kirpies, you're reaching for your button? Or Commissioner Goldman, either way. You two choose.
Thanks. Yeah, so I think in this case, you don't have to go down hypotheticals, even when you're talking about the significant losses of a service of a building manager, because you just think about the day-to-day things that building managers do, you know, letting people in, whether they're repairing something, sometimes even like mail packages, services. They provide a lot of very valuable day-to-day services. So I think that should be considered, and I agree that the amount should be higher, and I think higher than even what staff recommends, and I'd be amenable to discussing with colleagues.
And now Commissioner Kirpies.
Thank you. Yeah, I think staff, their analysis that the minimum should be reserved for the most inconsequential violations of the residential manager requirements. You know, examples include where a resident manager is on site, not working the full hours, they didn't hang up the sign, you know, things like that we hear about all the time. So I don't necessarily agree that, you know, I'm not so upset or offended by the $14 low value, because I know that there are certain situations that might apply, but I agree that it must be higher. It doesn't sound like we're going this direction, but this is a case where I wouldn't have objected to sending it back to a remand with an explanation that, look, that's what $14 is for these little things. So take all that into consideration and come up with a new number. But I don't mind if you guys come up with a number, as long as it doesn't sound crazy high or something. I mean, I'm okay either way. But yes, I agree that it needs to be higher than 14 and maybe higher than staff.
Thank you. I echo what my colleagues said. I have no objections to anything any of them said. For me, this hinges in a large part on the consideration number 5, the extent to which the tenants were led to rely upon the fact that the service would be provided. I don't know if Mr. Rusnow presented that impressive list of former managers to the hearing examiner. It's irrelevant to the fact that we have long-term tenants who have relied on this service for things that are probably very inconsequential and for some things that are very consequential. For me, that is what it hinges on, is I think that the lower amount might even, if somebody moved into a new building and they had been there for a month or two and then all of a sudden there wasn't a manager, they hadn't relied on it very much. But when somebody's been there for 30 or 40 years, they have. So for me, these tenants in particular, although it applies to all the tenants in the building, these tenants in particular have shown that this is certainly part of their expectation with the rent they pay on a monthly basis. So I definitely support staff's recommendation. I would be amenable to a larger amount. I was not suggesting a dollar amount when I suggested the halfway point of $65. I offered it because I did the math on all of them when I was doing the math a few minutes ago. I did it earlier today, but I checked my math a few minutes ago. And so I think that 35 is what staff's recommendation. I hear that that's the will of the commission to move up. The tenant said 90, and the halfway point 65. So I'm interested in my colleagues. Where are we in that neighborhood? We're all talking about a higher number, but no one's landed on anything yet.
You're not going to like what I have to say. I would actually leaning towards the maximum, 116, because of the how essential this service is. because of the importance of relying on the manager services, as you, Chair, as you mentioned, especially for those tenants who've been there for many, many years. They definitely relied on the service. So the regulations provide those factors as we discussed in the prior appeal. And I want to read this that allows to go, above and beyond of what is in the suggested guidelines, but to be reasonable and balanced. And if we want to stick with the regulations, I would suggest that because of the significance of the reduced service in relation to the quality of life, safety, health, convenience, and comfort, and there could be many instances or scenarios where the presence of the manager, on-site manager in a large apartment building with 40 units could argue that that service could be essential. And it is justifiable based on the tenants' reliance on the service. I think we could actually go with a maximum in the guidelines. Since the examiner could go with a minimum, so then why we cannot go with a maximum? So what I'm saying is that why the fact that we're using the higher end, the maximum or higher end, not the maximum but higher end, is just something that you cannot even entertain. Why you have to look for something, if we believe this is a significant reduction, a substantial reduction, so then we should, by giving a higher amount, we demonstrate how important the service is for the residents and how seriously the rent stabilization ordinance looks into this type of services. And as I said, the city council also looked into this type of in the on-site resident manager topic, and they clearly their direction was these cases should be looked in a way that this is very serious for the city of West Hollywood. So I don't believe there is anything wrong to go with the higher end of the guidelines. Thank you.
I appreciate that, Commissioner Topchin. Let's just kind of take a survey here and see where we can come on a number. I think that's probably going to, because I think we're all going the same direction. That's what I hear. We're all headed the same direction, but I want to land on a number that maybe we can get a consensus around. So is anyone else willing to kind of throw a number out there? This is sausage making. Unless somebody wants to make a motion and vote it up or down, I think that it might make sense just to land on a number to make the resolution easier and make a final vote just up or down. Commissioner Goldman, sorry. I was looking at Copeland, I almost said that.
So I agree with Commissioner Topchin. I would support the 116 just because of the size of the unit, and it is a really significant service.
Any of the Commissioner Kirpies? I see you're reaching for a button.
Yeah, I would just, so I agree with most everything that Commissioner Topchin was saying, except I hope that our resolution doesn't include anything about length of time, because I understand the examples you're trying to give, but it doesn't mean that someone there for 1 month would have any less reliance on a manager. So I don't think we should use time. We didn't use it last time. We shouldn't use it this time. I also would prefer that if we, and I think we are doing this, but instead of coming with a number first, unless you have justifications when you're talking about that number, I think we should come up with justifications of where we're heading first and then put a value on that service. Because again, that's what we're doing. We're trying to place a value on what the missing service is. It's not a punishment. And I would argue, just for fun, I would argue that the city clearly isn't thinking this is very important because there's been no prosecutions that I'm aware of. But that's just, I'll just say that.
So Commissioner Kirpies, you have a value that you were thinking of for this service. and
I
your
have
rationale?
not. I have
Okay.
not. My comment was that it was higher than, I would be fine with higher than staff, but that's as far as I've gotten thinking wise.
And I pointed out the length of time, not in the length of time they've been without the service, but the length of time they have been tenants, just really underlines the amount that they relied on that service and had a history of relying on the service. That's the point I was trying to make, but I don't think that belongs in their resolution. Simply to say that we number 5 is important to me is sufficient. Commissioner Copeland, Vice Chair Rory, do either one of you have any rationale of the value of the service?
As far as numbers, I think it should definitely be above the mid-range. It should be in the higher range. An exact number, I'd like to hear from my colleagues what they think. I've heard Commissioner Topchin and Commissioner Goldman. I'd like to hear what the rest of you think. I definitely think it does need to be at least in the high range, if not the maximum.
Please, Vice Chair.
I would probably support a 65 mid-range number, which is higher than what staff's already recommending. And the reason I feel a little constrained about going beyond that is because I'm extremely mindful of the task with which we're charged, which is to look at what the hearing examiner did and see if there's substantial evidence to support that. And I think, as I understand the hearing examiner's logic, there was a short period of time from which the last manager had vacated or resigned or whatever, or left, until the appeal got filed, and there wasn't as much of a robust record, perhaps, of what the loss of this service meant, and that's why that wasn't taken into account at the time. And the extreme from the 14 to the maximum, it's just hard for me to go that much of an extreme, knowing that I'm supposed to look at what the hearing examiner looked at and make my decisions based on that. And that's why that pulls me back to the mid-range of around 65.
Thank you. And so that I weigh in, following our model from the last appeal, the mid-range seems like a good place to me. But I also noted that the tenants identified that the value for them was around $90, which I think is part of the justification is understanding the value that the tenants got in their rent. And I didn't hear any reason how they came up to that number, and perhaps that would have been a good question to ask them before we closed that public hearing, but we didn't ask that. So that's kind of where I'm at. I'm not comfortable going to the absolute extreme. I hear your argument, Commissioner Topchin, that there is no reason. Just as much justification can be made for the bare minimum as the maximum. I mean, that makes sense to me, but I think they got it wrong with the minimum, so I don't think that we would get it right by doing the maximum either. So I'm in kind of that 65 to 90 range is what I think the value for a 40-unit building that has had the service for decades. I think that's kind of where I'm landing. But if somebody wants to attempt a motion, I think it might be time to kind of get to that point. The number's the only thing that would be changed on the resolution, I think.
So I want to, before we go there, caution going to the maximum. If you do, that's your prerogative. However, the guidelines that we looked at in the last case, the 1 through 8 different options, all come into play here. And the regulations do require that all factors be looked at. We, in the last case, looked at the ones that are most impactful for arriving at that amount. I think, based on the record, the commission would be hard-pressed to say that all 8 of those apply to this, which would be how I think you would need to be, or at least 7 of the 8, something very close to get to that maximum. So I would just say if you're going for the max, we'd have to go through those and discuss those. But if I think based on the record, again, that not the minimum and not the maximum range is a very subjective area. It's when you start hitting those other sides that we have to look really carefully about how we craft the resolution, because what that resolution is one, it's the direction to the parties of how they have to behave, but also what gets looked at in court as to why the commission did something and the justifications behind it.
Thank you. Commissioner Copeland, I see you looking.
I was just curious, what if we were to not go to the maximum, but a little higher than the mid-range, like talking about 75 or 85 as opposed to 100 and something, and also as opposed to 60, but somewhere in the middle? I think we can justify with enough of these, the 8 considerations to do that.
I've heard some discussion around the prevailing market value of the housing service in our debate tonight, our discussion, deliberation, which is number 4. The comfort, number 3, of the rental units has been discussed. I think that maximum allowable rent for the units is a range depending on how long people have lived there, so it's not something we really can discuss tonight. But I said number 5 is a really big one for me, and I think that's been addressed. So I think that we've hit a bunch of them, just maybe not all eight of them. So if, again, I think Commissioner Kirpies has more to say, but I do think that we're pretty close to a motion if somebody wants to try it.
I was going to say, I've been convinced to go to the middle ground based upon, or the middle number based upon a combination of both the evidence, well, all the evidence, but the fact that, they did talk about, the convenience of having the manager there, which adds value, but then also not the extremes to where, like, nothing ever gets done at the property. It doesn't sound like this is a property, well, in this case, this does not sound like this is a property that is decrepit and all that, and falling apart. So part of the services of the manager is making sure that things like that stay up. The landscapers come, things flow normally. Granted, there's a huge loss there because they're not there. So a lot of that's an expense, but it sounds like the landscapers are still coming. The things are getting cleaned, the stairwells are getting cleaned. So they're not getting all the services, but they are missing some of the service, or they are getting some services. So I'm fine with the middle now. I mean, I'm much more fine with the middle now than what I was when we first started this conversation.
So my notes here show that I'm counting 3 of us at the high or maximum of 116 against advice of legal counsel, or with more discussion required to get to that point from legal counsel's perspective, which I think is very important for us to consider. And I'm seeing 2 that are comfortable at the mid-range, and then put myself kind of at the mid-range to maybe slightly higher. So with that in mind, anyone want to take a stab at it?
I want to ask this legal counsel, and the factors number 1, 2, and 5. When I'm reading it, it seems like 1, 2, actually could be 3 as well. 5. If these are, well, to me, and I wonder if the commissioners believe these are the factors that could be used. Will this be sufficient to say, to kind of ask for a higher, to determine on a higher, and not necessarily $116? It seems like everybody's panicking about the maximum, but as to the higher amount of, above the medium range, closer to the maximum. So what is it that the council looking for? What kind of justification besides this number 1, 2, 3, and 5, for example, to justify a higher end?
It's to get to a range that's in the middle, you would just need to make some of those. But if you're trying to hit the very lowest, you would have to say none of those apply or 1 applies, and the top you would need 7 or 8. So if you're working in that subjective range, I've heard 60 to 90 being batted around. I think having 2, 3, or 4 of those factors would be sufficient.
Okay. All right. Yeah. Thank you. I think we have here 1, 2, 3, 5. I don't know if other commissioners believe that some other factors can be also used.
I think number 4, the prevailing market value. I mean, that's having a unit with a manager is definitely market value, increases the market value, but Vice Chair Rory?
I would say number 8 as well, because the size of the units versus the minimum unit threshold.
Size of the building.
Yeah. But I'll take a stab at a motion. I don't
Please.
know if this will work. I would make a motion to adopt and modify resolution 25-678, with the modification being that instead of it being $35, as staff recommends, that we put it at $80, which is above the mid-range, but slightly above the mid-range, but not the extreme, and would certainly seem to be justified by the factors that we've articulated. 1, 2, 3, 4, 5, and 8 being the size of the units in the building.
The number 80 being replaced in the resolution is the motion. Is there a second? Failing to see a second, that motion dies. Is there another motion?
I'll move the same exact wording with the dollar amount 65, which is the middle range, right?
Midpoint, yeah.
Yeah.
Now there is a motion for 65. Is there a second for that?
I'll second that.
There being a second, is there further debate? Any further?
I didn't support the vice chair's motion because I thought I wanted to see 85 or 90, but definitely I'm not going to support the 65.
Let's take a vote on this unless there is an alternative motion that would supersede it. Seeing none, let's
I'm
please.
sorry, can we do an alternative motion?
I believe that would be in order.
Okay.
I was reading the tea leaves, and I think that would probably be the best approach.
Okay. Alternative motion for me would be 85.
Is there a second for the alternative motion?
Second.
There is a second. So the way this will work is we'll vote on the 85. If that fails, if it passes, we're done. If it fails, then we will go to the underlying motion of 65 and vote on that. Does everyone?
Chair, to clarify, it's 85 in the substitute motion, 65 in the follow-up if needed, and
Yes.
then amending the findings as to numbers 1, 2, 3, 4, 5, 8, and 8 is due to the size of the building being 40 units.
That's the motion as I understand it. Is that correct?
That's correct.
Okay. The substitute motion will be voted on first. Again, if it passes, then we're done. If it does not pass, then we'll go to the original motion of 65. Everyone clear? Okay, then we will ask the secretary if she's ready to call roll on the substitute motion by Commissioner Copeland.
Commissioner Copeland?
Aye.
Commissioner Goldman?
Aye.
Commissioner Kirpies?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Rory?
Aye.
Chair Bass?
Aye. That motion carries. And if the parties in this case have any further questions, you can reach out to the Rent Stabilization Division at 323-848-6450, by email at rsd@weho.org, or you may request an in-person appointment online at weho.org under the services menu. That concludes our appeals for this evening, which means we will move on our agenda to item number 9, unfinished business. Mr. Kessinger, do we have any? Well, there is nothing on this. So now we'll go to items for staff, which is what I'm supposed to call on you.
No items from staff at this time. Thank you.
Thank you very much. Appreciate you guys helping us get through this tonight. Public comment. This is an opportunity to address items that are germane to the commission that were not on our agenda tonight. Do we have any public comment?
No public comment.
Okay, then we will turn to items from commissioners. Do we have any commissioner comments? Vice Chair Roy?
To note that I will be absent from the next meeting on May 8th, I believe.
Thank you. And we are a 6-member commission as appointed at the moment. So if there are any other absences, I would just caution the commission to please let us know as soon as possible so we can notify all the parties. We have to have 4 of us here to conduct business.
I'm absent the second one of May, the second meeting of May.
I believe the council will probably give us our 2 at-large commissioners at the next council meeting is my goal, or not my goal. I don't get to set those goals. My hope, but yeah, thank you for letting us know. Any additional comments? I would just want to acknowledge the really great work of now former Commissioner Alex Paris, since he wasn't able to be here, since we didn't know his last meeting was his last meeting. I just want to acknowledge that it was a pleasure to serve with him and extend without objection our thanks to the commissioner for his work.
Absolutely.
Anything else? Then, if that's the case, we will adjourn this meeting to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on, I'm trying to look up the date, even though, let's see, the 15th of May? May 8th, you're right, May 8th, 2025 in West Hollywood Park Public Meeting Room, Council Chambers, which is this room. Have a great night.
Types of housing we need for the future.
Typically, the process begins with an assessment of our existing zoning regulations and a community and stakeholder input process. And so we evaluate what our zoning looks like today, what that allows for, what we might be trying to achieve through those changes in order to help us reach those goals.
So we're really trying to introduce more tactile activities for people. Usually community meetings involve question out to the public and then an answer back. So what we're trying to do is really collect statistical information, but